First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, great state of Florida, and this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have one case on the docket today, Lisa McGowan versus Bobby Ray McGowan. Counsel, if you are ready, you may proceed.
May it please the court, Rebecca Creed on behalf of Creed and Gowdy. I'd like to reserve 5 minutes for rebuttal, please.
So noted.
We represent the appellant wife, Lisa Miller, formerly known as Lisa McGowan. Ms. Miller asked this court to reverse the trial court's final judgment of dissolution in its entirety, with the exception of the paragraphs that dissolve the marriage and restore her to her her maiden name. There are three main reasons I'd like to focus on today, although the brief does raise additional issues related to alimony, the use of a wrong standard, and attorney's fees. I would like to focus on really the first four arguments of our brief, which are that the trial court erred in adopting verbatim the husband's proposed final judgment, which reflects a lack of independent decision-making, that the trial court misidentified and misclassified marital assets as and marital liabilities, and in fact designated plainly non-marital assets like the public stock as marital assets and included those within its table of net values of marital assets for distribution. This also includes misclassification and misidentification of other stipulated non-marital assets like premarital interests in the retirement accounts and the husband's Fayetteville, Georgia home. And lastly, the trial court's inequitable distribution of the parties' marital assets and marital liabilities, including its refusal to award any marital share in the Fayetteville home, despite the fact that the evidence revealed that the husband had paid down on that mortgage with marital funds.
And counsel, before you jump further into the issues, you started with asking for an affirmance in part and reversal in part, and I just stopped me to go back to the initial and reply briefs. Both ask that the final judgment and dissolution be reversed in its entirety. So can you explain the change in position today at oral argument?
I'm sorry, Your Honor. We would be happy with reversal in its entirety, and if that's what it was limited to in the conclusion, we will stick with that. I just would note that in our first issue on the verbatim adoption, I think we did mention that the parties' marriage should still remain dissolved, but happy to stick with reversal in its entirety.
Okay, thank you. Just so with that housekeeping matter attended to, let's discuss a little the equitable distribution plan. And you've identified a number of alleged errors in, on the one hand, the trial court classifying some marital assets as non-marital assets and also some non-marital assets as marital assets. Is there any language in the judgment that would allow, any of these individual classifications? And we can go through them, starting with the Infinity loan. Is there any way to uphold the trial court's finding that was, a non-marital liability?
No, Your Honor. In fact, the husband testified at trial that he owned two marital assets with the wife, the Amelia Island property and the 2015 Infinity. I think that was at page 1500 of the record. In addition, the parties acquired this asset during the course of the marriage. The title and the loan were jointly titled to both parties. The husband contributed a $1,500 down payment during the course of the marriage to purchase the car, and the wife made the payments from her marital checking account and marital earnings. Those facts are all undisputed.
Is there any CSE in the record that would support the trial court's finding that it's non-marital?
No, Your Honor, there is none. In fact, the only rationale that the trial court gives for finding that it's non-marital is based on some perception that, well, because the husband didn't use the car or wasn't responsible for it, then he shouldn't have to share in that marital deficit. But nowhere is that a factor within the statute itself.
So moving on to the MasterCard, again, is there any CSE to support the trial court's conclusion there that that was a non-marital asset, or the trial court's finding that there was a premarital balance?
No, there is not. The wife testified that she believed she had opened that credit card during the course of the marriage, and she certainly testified to marital debts and expenses that she had paid by using that credit card, including expenses for the marital home and for herself. And so the date of the balance was roughly $8,500 that she asked the trial court to distribute as a marital debt. And again, the trial court's rationale related more to, well, it was only titled in the wife's name. Under 61.0756A1, it doesn't matter if it's an asset acquired during the course of the marriage. It can be titled either individually or jointly.
Okay. Well, let's move on to the First Florida accounts. The trial court found that the First Florida accounts had both marital and non-marital funds and valued it as at $163,000 as the date of filing. But the trial court awarded $61,000 to the wife. Is there anything in the record that would support that mathematical calculation and deviation for that, either 163 or half of 163 or some other calculation that leads the court to find $61,000 as the appropriate distribution?
Your Honor, I believe that calculation is supported by the record because the wife testified that of that 163 balance, $102,000 was her inheritance. So she did ask that inheritance be excluded as a marital asset, so that left the court with the $61,000.
But even with that, the trial court found that there was both marital and non-marital assets, correct?
Yes.
So would it have been correct to distribute the entirety to the wife?
No, because she did ask for that amount be designated as non-marital because it was her inheritance.
And I'm
And that was
misspeaking,
maintained.
excluding the inheritance,
Oh.
the remainder. So
Oh.
should that $61,000 remainder, which was classified as marital and non-marital, should that have been distributed in its entirety to the former wife?
Oh, to the former wife in its entirety? No, I believe that should have been equitably and equally distributed between the parties.
Okay. Same question for the Jacksonville federal account. That appears to be a non-marital asset, and that was distributed to the wife. Any challenge to that distribution?
Not a challenge to the distribution that was non-marital because it represented, again, funds that the wife had inherited and used with her siblings. But I would submit that the issues that we have with the valuation are that the trial court's table, while its findings consider certain non-marital assets, the table itself, this chart on pages 390 to 391 of the record, include those to illustrate the net value of each marital asset and debt to the other party. And that's one of the issues that's prevalent throughout this, is that the trial court should not have distributed non-marital assets as part of the equitable or unequal and inequitable distribution. And it really reflects that it's not. The trial court, I think, used those numbers in an effort to show that even though it was an unequal distribution, maybe it wasn't such a great discrepancy, because under the trial court's rationale, there was only a $30,000 difference. But in fact, if you take out the identification of the value of these clearly non-marital assets, the most important and significant of which is the public stock, then what it really turns out is that the husband is receiving more than $200,000 more in marital assets than the wife.
Okay, and we could certainly go through 8 other assets, including Merrill Lynch accounts, IRAs, real property, and discuss the valuations and whether it was marital or non-marital. But if we agree with your arguments that the equitable distribution was flawed and the trial court committed reversible error, is there any reason that we need to reach the alimony issues, the attorney fees issues, or anything of that sort, given that that would require need and ability to pay?
No, not specifically as to those issues. They would all be considered. We would ask that the entire, if this court reverses the entire equitable distribution scheme or inequitable distribution scheme, then the alimony findings, rulings, and the attorney's fees would necessarily need to be returned to the trial court for basically an entire do-over, because those are interrelated, and necessarily findings as to alimony and attorney's fees may be impacted by what the trial court would rule on equitable distribution.
Thank you.
Well, I would like to reserve my remaining time for rebuttal. Thank you.
Okay. If my colleagues don't have any questions at this point, we will continue with the argument, and appellee, you may present.
Well, good afternoon to you all, and appreciate the opportunity of being here. I'm here on behalf of Mr. McGowan. And if I'd like to just begin by looking at this thing as the judge saw it, if I could do that, from 30,000 feet. Here you have a situation where if he'd have done exactly what they wanted to do and what counsel's wishing you to agree with, after the wife would end up with $1,334,706.31, and the husband with $969,126.27. That would have given her $365,580.04 after a 6-year marriage, 4 years of her being in retirement, and 2 years of litigation going forward. This trial lasted 4 days. It was, and everyone was fully heard by the judge. He saw everything he saw, and what he did is he sought to seek justice by utilizing the elements that are available to him in the statute. And he did that going through the assets and the liabilities and everything about it. But when he came up with the unequal distribution, he under 61.075B, the economic circumstances of the parties, the distribution of marital and non-marital assets left the parties with estates valuing about $800,000. So when they got married, they're both making about $100,000 each. They had similar accounts in retirement and other assets. And then when they get divorced, or while the wife was working, I hate to call it the wife, but while Ms. McGowan was working, she was an executive with CSX Railroad. And he was a fellow who ran finance and heavy machinery. But her last year, before she retired and retired voluntarily, when she retired, she was making over $200,000 a year. So the judge, in his wisdom, in his discretion, left both parties with the asset situation at about $800,000 each.
Well, and there's no question that the trial court has discretion to do equity, and there's no question that the trial court had discretion to make an unequal distribution. But doesn't the trial court need to follow the statute first and specifically designate what's marital, what's non-marital, and if something's unclear, to explain why he's making a determination that differs from what the facts support?
Well, as I remember the brief on behalf of the appellant, they were talking about the public stock, which she got in her prior divorce. She was divorced after 16 years, and he had a first wife who died from cancer. But she ended up with that public stock. Well, the judge didn't say that is equitable or non-equitable. What he did is use that as a background. In other words, when these people walked into this very short-term marriage, they walked in about equal, and he was letting them out about equal.
And again, I understand that a trial court can reach that conclusion, but the statute requires first to go through, designate what's marital, what's non-marital, non-marital before making, the presumptive equitable distribution. And if the trial court decides something else should be done, right, the trial court then needs to make some findings. So we can go through each of the findings by the trial court, as we did with appellant. Can you explain what CSE there was in the record to support the trial court's distribution of the Infinity loan solely to the wife?
Well, and again, I will give you that one. I think that there is no testimony about it, except that he never used the car. He never made a payment. He made a $1,500 payment on it, but she made all the rest of the payments.
So you concede that?
Yes, ma'am.
Okay, let's go to the MasterCard. Do you concede error there?
Yes, ma'am.
All right, what about the First Florida accounts?
Yes, ma'am.
All right, the Jacksonville Federal account, do you concede error?
I think that's argumentative on that one. I wouldn't concede that one at all.
All right, well, if we even take those three items and look at the fact that the trial court made errors in designating something as a marital versus non-marital asset, doesn't that require us and compel us to reverse unless there are some very specific findings explaining why those decisions were made without any competent substantial evidence in the record?
No, ma'am, I think that in what you do, you have what they call line item veto. You can decide some things are part of the reversal and some things are not. And so there are other things that we would submit to you that are not subject to reversal, and that is the judge trying to do equity and justice. I know in 61.075C, the duration of the marriage is one of the considerations. Well, this marriage was a short-term marriage of just over 6 years, and they didn't hardly live together at all until about November of 2017. So it was a very short-term marriage, and it was a very independent marriage. She had her own retirement, her own assets. He had his own retirement, his own assets. She had her own credit cards, and she paid all those bills. He had his own. And they didn't have any joint accounts whatsoever. So they lived kind of independent lives.
I understand your argument, but I'm going to ask the same question I asked the appellant. If the equitable distribution plan is flawed and we reverse on that issue, then the trial court necessarily has to go back and reevaluate alimony and attorney's fees, because he would not have any way to determine, absent that equitable distribution, whether there was a need or ability to pay for either party, correct?
Well, I would suggest to you that the position of these parties, even in what he did, what the trial court did, they are equal. They came in with about the same amount of money, and they left with the same amount of money, according to the judge. And the lady voluntarily retired. She took away a third of the income of the household for 4 years of their existence in a marriage. So I don't know that he would have to consider alimony. Alimony is based on duration of the marriage and on the ability of someone who needs it.
Correct.
And someone who can pay it. Well,
So
she doesn't need it, and she tried to say she needed it, but she doesn't need it, obviously, from the money that she has going into the marriage and coming out of the marriage. She's got
So it
lots
sounds
of
like to
money.
me that you're saying the trial judge, just needed to look at how much money there was on either side, could just equalize it, really didn't need to go to the trouble of deciding what was marital, non-marital, evaluating any of it. Just look at the total number and divide it in half.
Well, that's called justice and fair.
Okay?
And that's what he was doing. And that's one of the categories. That's one of the categories of 61.075J. Any other factors necessary to do equity and justice between the parties, and that's called equity. It's called
Counsel,
justice. Yes,
opposing counsel, I think, suggested that her argument is that she was shorted about $200,000. I think I heard that total number. You've conceded a couple of the line items, if we want to use your budgetary gubernatorial veto metaphor. So if you concede those three items, what is the difference in the parties' positions?
it's a very low number. It's not the numbers which he's talking about. It's a very low number. And
So your argument is essentially then, if there's error, it's harmless error?
yes, sir. And again, and I know that when you look at marriages from your perspective and things that you do here, but this was a situation, this trial was 4 days. I mean, the judge was there every second of every day, and I know the counsel says, well, he adopted our proposed order. I'm sure they wished he'd adopted their proposed order, but and he did that, but he did it because he agreed that one of the things that we were pointing out about it, and one of the things that's underlying of this order is the justice aspect. You know, this lady who decided to quit her job, and she never got another job during the time of their marriage. She didn't even go seeking a job. We had a person who came and evaluated her for her ability to work and continue to work. She was only 57 years old, and to me that's very young. And so I would submit to you that she never tried to get a job. And then reward her with their distribution and hand her this $365,000 after a short marriage, after her not working. Now, he worked all the way, continued through. Now, he kept putting money in his retirement. He kept putting money in situations that were his, in his 401k. She did not. She was not, for 4 years she didn't do that. Well, she could have. And there's no evidence she was ill, no evidence she couldn't work. In fact, the lady that did an evaluation of her was a very renowned expert and said the lady can make anywhere from $40,000 to $85,000, you know, not counting promotions and things like that. And so I would just submit to you that the judge, in his wisdom, I would say, looked at this situation, and why should you reward somebody in such a short-term marriage? Now, the only asset is really the public stock. The judge never said that was the biggest thing she had. He never said that was a marital asset. He just said he took that into consideration in looking at her background as to whether or not she could exist. Can she survive? Well, sure. She's got that $400 and something thousand worth of stock out there. Now, the only thing he had that's really out there of some prominence that was a dispute was the house up in Fayetteville, Georgia, which was owned by his former wife, and she left it to him and his 2 daughters. And so that was the really only big things in this divorce, and the rest of us, a little bit here, a little bit there. But he never said that the significant things were marital. He just took that as background, is can this lady survive? Can she exist? Can she have the life that she's used to? And he came to the conclusion, after evaluation of all the evidence, evaluation of all the witnesses, and he came to the conclusion that justice requires that we work this out with an unequal distribution. And so that's kind of our position. And I don't want to take you your afternoon, but that's our position, and we're sticking to it. It's certainly staying on our briefs. And I've admitted all I want to admit to you today. And the rest of it, I think that we have a very persuasive argument for it. And I thank you for your kind attention. I know you're not going to be having a rebuttal to her, but I'll just go ahead and sit down. But and thank you very much.
Thank you, counsel.
May it please the court, counsel for the husband has essentially just conceded that, at least as to several significant assets, that those must be reversed. We would reject any attempt to line item veto this equitable distribution scheme, and the entire final judgment is so flawed that it must be reversed and remanded. The language of paragraph 5, despite counsel's attempt to portray the designation of the public stock and other assets as just background information, in the language of paragraph 5, page 390 of the record, the trial court finds, given the inequitable distribution awards herein described, the court shall illustrate the net value of each marital asset and debt to the other party. So it is clear that what the trial court has done is adopted verbatim the husband's proposed final order, which is very favorable to the husband and very detrimental to the wife, and it's at least a $200,000 difference if you were just to consider truly marital assets and marital liabilities, and we set that out in our initial brief.
Well,
Was it your understanding, was it your understanding that what the judge concluded below, like your brother says, is swept in under J, that in the end, the judge was aiming to do equity and justice between the parties?
No, that is not our understanding. The judge really only pointed to, in attempting to justify the unequal and equitable distribution, pointed to two factors under Section 61.075, the economic circumstances of the party and the duration of the marriage. And really what the trial court did was look to the financial earnings and the financial contributions of the husband during the course of the marriage, the fact that he did earn more and was able to contribute more to the retirement, to say, well, that justifies now that the wife shouldn't be able to come in and get a portion of that marital retirement. That's a point that's continually overlooked in this case, is that marital assets, marital earnings were used to fund those marital retirement. And it's not enough just to say, well, I kept it in my name. Those were marital retirement funds, at least a portion of them, and the trial court doesn't even take that into consideration, the stipulated non-marital portions in its calculations.
I'm interested in a similar point. Under subsection J, kind of the due equity provision of the statute, could a trial court, if they made very detailed findings on the equities of the situation, basically just skip all of the equitable distribution in its entirety and ignore, just add up the how much money there is, just do some math, and then here's what I think?
No, Your Honor, because the language of 61.0751 requires the trial court to first make findings as to what is marital and what is non-marital, then to set apart to each spouse the non-marital assets and only equitably distribute the marital assets and liabilities. And further, the language the statute starts with the premise that the distribution should be equal.
Right, and I want to get to what Judge Thomas asked is, assuming all of that was a complete mess on the equitable distribution, why isn't it harmless given the trial court's findings under subsection J?
Because the language of the statute also requires that there has to be justification for an unequal distribution based on all relevant factors. And here, if you accept that there is one relevant factor, which we dispute that one any other factor necessary to do equity and justice between the parties even justifies the trial court's ruling. I'm not sure how consideration of non-marital assets could ever be considered within that catch-all factor if they shouldn't be considered under any of the other factors. The economic circumstances of the parties and the duration of the marriage, this was not such a short-term marriage as to justify a totally unequal and inequitable distribution scheme. Even the trial court found that these parties contributed and supported each other. The wife wasn't retired for 4 years of the parties' marriage. They were married in 2012. She retired early in March of 2017, and she filed the petition in 2018. So at most, she was retired for 1.5 years, not 4 years, and she did contribute her marital, to the extent she was receiving pension amounts, she contributed those, and she paid marital expenses. And so it is grossly, I would submit, grossly inequitable to look to one catch-all factor to attempt to justify an unequal and equitable distribution. So we would ask this court to reverse.
Thank you, counsel. Thank you both. This court will stand in recess.
All rise.